we got to talk about Alex Murdaugh, because since the Supreme Court overturned Murdaugh's conviction, he is now pending trial. The question then is, what happens next? Well, the prosecution says that they are going to re-prosecute the case, and the Supreme Court has now appointed a new judge, which means we should start to see new court dates, because they're going to have to put a court date on the record and start setting this on a trial schedule. We are getting into the beginning steps of Alex Murdaugh Take 2. There is a new motion that was filed at the Supreme Court level, and I'm really interested to look at that with you all, because it has to do again with the egg lady juror. I am so curious, and I looked at the beginning of this motion and went, oh, the law nerds and I just need to chat. The law nerds and I need to chat. I am so curious about, well, what this motion entails and what's going to kind of shake out from there. Let's take a look at the order for a new judge. On March 2nd, 2023, the defendant was convicted of 2 counts of murder, 2 counts of possession of a weapon during the commission of a violent crime, and he was sentenced to life imprisonment on March 3rd, 2023. Do you remember how wild that was? On October 27th, 2023, has it really been that long? The defendant filed a motion for new trial, which was denied by the circuit court. On May 13th, 2026, the Supreme Court of South Carolina reversed the denial of the defendant's motion for new trial and remanded the case to the circuit court. The circuit not being an appellate court, that being the trial level court. They're called different things depending on what jurisdiction you're in. In New York, the trial level court is also a Supreme Court. There are superior courts. There are justice courts. They all have different names. That's the trial level court. Pursuant to Article 5, Section 4 of the South Carolina Constitution, it is ordered, all caps, that the Honorable Deborah R. McCaslin, I hope I pronounced that right, be vested with exclusive jurisdiction. We're going to talk about what that means, because that's different than some other appointments. Notice at the top of this order that these are all different indictment numbers. Those different indictment numbers are for each of the different charges, but they all go under different indictment numbers. But those are for each charge. They go on to say that the judge has exclusive jurisdiction, including general session matters, trials by jury, and civil forfeiture actions, and all motions arising from the above referenced indictment numbers. That's the murder, the possession of the weapons, etc. Judge McCaslin's jurisdiction includes jurisdiction over any future retrial on the murder charges and any related matters. Judge McCaslin shall decide all matters pertaining to these indictment numbers, and pursuant to this assignment shall retain jurisdiction over this case regardless of where she may be assigned to hold court. Pursuant to this assignment, Judge McCaslin is to have and exercise all powers and duties appertaining, that's what it says, to a circuit judge of the 4th Judicial Circuit while presiding over this matter, John W. Kittredge. Emily, what does that mean? That means that this judge is not a judge sitting in Carleton County. This is a circuit court judge who has been assigned to handle this case no matter where this case takes place. So if there's a change of venue motion, to have this case tried not in Carleton County, but in Charleston County or wherever, this judge follows the case. Everything to deal with this case goes to this judge. So I'm keeping an eye on the docket to see when we get a new court date. And in keeping that new court date, there was a new motion filed, and I'm curious about the impact of that motion. We're going to look at that next. And a quick break to talk about our Case Brief sponsor, Incogni. You've heard me talk about Incogni on stream, here on Case Briefs and podcast and everywhere else, because so often we're looking at cases where personal data becomes a topic of conversation. At the end of May, people were using Meta's own chatbot function to gain password reset access to people's Instagram accounts. So every day it seems like it's something new where you can get locked out of accounts, have other people accessing your personal information, and you just need someone to monitor it all for you. And that's what Incogni's for. One of my favorite things about Incogni is that I can set it and forget it, not just for myself, but for my family members, because they go after the data brokers that are continuing to spread and sell your information all around the internet and start taking it down. You can see the progress of what's being requested to be taken down if you need to take more action to get something taken down. And they even have a custom removal feature, which means if you need a little bit more help with something specific, they've got your back. You're not just left hanging. So if you're ready to protect your privacy and start getting your information off the internet, Incogni is what I trust with my and my family's information, and I think it will work for you. Plus, if for any reason it doesn't, they have a 30-day money-back guarantee. So if you're thinking it's time to take back your personal data with Incogni, you're right. Now is the best time, because if you go to incogni.com/Emily and use code Emily, you'll get 60% off annual plans. Now let's get back to the brief. We are dealing with a motion regarding sealed and restricted records. Motion to retract conditional objection and unseal and remove restrictions as to the in-camera hearing transcript supporting Juror 785's removal. On May 13th, 2026, this court issued an opinion reversing appellant's 2 murder convictions and remanding for a new trial. The remitter was issued May 29th, 2026. To date, there is no order appointing a circuit court judge to preside over the new proceedings. That happened after this. In the same matter, the former chief directed that all materials for this action should be filed in this court. So we're getting a little bit of jurisdiction from the Attorney General. The Attorney General is saying that the reason I'm filing this motion to unseal before the Supreme Court, because this is a trial court level motion, and the court might actually kick it back to the trial court now that a trial judge is assigned. But this is normally a trial court level motion. And so the attorney is saying, you told us to come to you on September 4th, 2024, prior to briefing in the direct appeal. Juror 785 filed a motion to intervene with the intent to have this court unseal the, quote, in-camera proceedings related to the juror's, quote, removal from the jury. I forgot about that. I completely forgot that the juror themselves asked for the hearing where they were removed to be unsealed. Emily, why would Juror 785 ask for that? Well, at the time, Juror 785 had a lawyer, and remember, some of what they're asking to be unsealed is things that that juror was not present for. That's the hearings between clerk of court, defense, prosecutor, and judge. So I imagine lawyer for Juror 785 is like, but what happened in this proceeding? Because that was a closed-door hearing. Can you tell me what you were talking about me? We've only seen snippets. Juror 785 is literally saying, I want to be in the room where it happens. Of relevance here, under the provisions of prior orders in this case, the transcript pertaining to the juror's inappropriate discussions of the case with others prior to deliberations and her ultimate removal as a juror were both sealed and restricted from use outside the case. Specifically, Judge Newman, this judge,
bring the jury.
Judge Newman issued a strict protective order, but subsequently allowed all counsel, including counsel for the juror, Emily, keep reading, to have access to the records with the instructions that counsel was prohibited from publication or dissemination of any of those records. I do not want to read about this in the papers. I do not want to hear about it on a podcast. I do not want this to be on the YouTubes. I don't want to hear about it. Lawyer's eyes only. The motion goes on to say that the restrictions were by consent of the parties and the juror. Well, once they had access to it, that makes sense. Former Justice Toll essentially continued that order, restricting disclosures to anyone other than counsel. On September 16, 2024, the state objected to the juror's motion to unseal. Because the restrictions were opposed in a consent order, they could be rescinded by mutual consent in a subsequent court action. And they are quoting case law and the oppositions at the time. The state goes on to say, however, the state did not consent at that time, arguing that the request was premature given that no issue had yet been raised and that no evaluation of the context could be fairly made in such circumstances. On October 31st, 2024, this court denied the motion. Subsequently, briefing was completed and the in-camera hearing transcripts related to Juror 785 were included in the record on appeal, but fully redacted, meaning we can't see it. It goes on to say that the transcripts were included in the public record, but the public is unable to access those pages. And then it cites the public record. We're going to have to do a transcripts request. Footnote 3, the transcripts were redacted for the public filing. Additionally, a portion of the in-camera transcript involving Judge Newman's questions to the juror appears in the new trial motion records that the former Chief Justice ordered to be filed with this court. The court has considered a similar post-remittitor request from an appellant before, and then they go on to cite case law regarding the Blackwell case, saying that courts can do this after remittitor. The reason that matters is jurisdictional. Once the remittitor is ordered, the question becomes who is in charge of this case and who has jurisdiction over this case. Conclusion, based on the foregoing, the state moves to retract its prior conditional objection for order allowing the previously protected transcripts from Judge Newman's in-camera proceedings supporting the removal of the juror to be filed as a supplement to the redacted court record. Further, prior restrictions regarding the sharing, discussion, etc. of the transcripts or any matter related to the previously protected proceedings should be found moot. Yeah, such as that the parties and the juror may now discuss the same without offense to any prior order in this case. Respectfully submitted by Alan Wilson et al. I want to know the entirety of what happened in that hearing. I'm real curious because I want to know how much Becky fuckery there was going on. The way that this all came up, and I'm not saying the result is wrong, the way that this all came up with that juror was sus. Here's the thing. When we look at how this juror was removed, I don't, at this point, based on what I've seen, disagree that the court came to the right conclusion. How the court got there is curious to me. And the fact that it seemed to me, based on the limited record we've seen, that it was, oh, there was this Facebook post. I question the veracity of that. Oh, there was this Facebook post. Oh, it's now deleted. Oh, it wasn't him. Oh, it's this. Oh, it's that. Sus. It's sus to me. And then you get the follow-up, same juror. Oh, this juror was talking to people at her apartment complex and telling them her opinions on the case. There was a lot going on with regard to this juror, and it seemed that perhaps Clerk of Court Becky was, shifting gears on trying to figure out what it would be to remove this juror. That's my suspicion. However, this juror has said that the reason Clerk of Court Hill wanted to remove her is because they were having conversations that this juror wasn't convinced that Alex Murdaugh was guilty, conversations that never should have been happening on the first place. But that also leads some veracity to me that this juror might have been talking to others outside of the courtroom about how she viewed the case. I don't know if the clerk of court would have been gunning for this juror, which seems to be a possibility here, if the clerk of court hadn't talked to the juror and knew that the juror was sympathetic to Alex Murdaugh. So with that, I'm very curious about what happened in, the room where it happened with the egg lady juror, with what Courthouse Becky said, how it came about that this juror was talking or supposedly talking to neighbors or a landlord or something regarding this case, how the court questioned the juror, what the juror said, because all we saw of that interaction was that the juror was being removed before closing arguments. And the court said, do you have anything in the jury room? And she said, yeah, I've got a dozen eggs. And the court's like, you got what? And she's like, I got a dozen eggs. One of the jurors brought us like farm fresh eggs. And we all went, girl, get your eggs. But that's how she became the egg lady juror, because get your eggs. Nobody is going to argue about that. So with all of that, I want to know what happened. I'm going to be keeping an eye on whether these get unsealed because I want to know. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.